The Business Platform Regulation is a regulation which was enacted by the European Union last summer, and the deadline for compliance is the 12th of July, 2020. The regulation seeks for the first time in the EU to set out a series of rules to create a transparent and fair playing field between internet platform providers on one hand and businesses, including small and medium-sized businesses, on the other.
Well, this is a very interesting regulation because I think for the first time the EU Commission was looking to try to balance the power of the service providers, the platform service providers, and the businesses that use those platforms to sell on to consumers. And there was a recognition that there was a bit of an imbalance, particularly amongst the large providers and the smaller businesses that utilized them in the terms and conditions that were being used. And so what the directive and the regulation tries to do is to balance that, put certain conditions on the platform providers with respect to what they can do with the business, with the businesses. And it's yet to be seen to what degree that will be utilized, but it will allow the businesses to actually have a complaint process that they can go through if there is an issue that they perceive with the provider. And ultimately, if they don't feel they've got proper recourse to litigate, to bring a claim against the provider.
Any provider of online intermediation services needs to comply with the regulation. The regulation is quite widely drafted, and so it's a bit unclear as to who falls into that category, but explicitly named in the regulation are internet search engines, internet marketplace providers, app stores, and possibly payment providers. The B2B regulation applies to both members of the European Union and the United Kingdom. And the reason for that is because the regulation came into effect prior to the exit of the UK from the European Union, it essentially gets transposed into domestic legislation.
The regulation requires certain provisions within the terms and conditions that the providers now have to enter into with the businesses. In particular, in areas such as suspension and termination of the agreement, they now have to provide notice. A very important element is a complaints handling system that all of the providers will now have to build into their agreements so that the businesses will have a means to try to redress any issues that they feel they have with the provider. That is something that then also leads to mediation, because what will be required of the service provider is that they actually name at least 2 mediators that would be involved in helping to resolve disputes with the business. Which is a new provision which many of the agreements currently will not have in it. The types of disputes that will likely arise from this are really disputes to do with the way the provider is handling the business. And one of the areas which I think the Commission in particular has looked at is algorithms, and how algorithms push certain suppliers to the forefront when you actually try to find somebody on the internet. And there will have to be more transparency with respect to how those algorithms actually work. There's also an emphasis on dealing with most preferred customer type status, where certain businesses had preferences over others if you went on to a particular website. So there'll have to be more transparency about that. And there will also be scope then for businesses to raise complaints and to have them resolved through the complaints handling mechanism that has to be built into the agreements. Another, of course, important matter for the EU Commission is the way data is being handled, and in particular, where providers may, in the past, have utilized data for their own benefit and perhaps sold data on. So where they've gathered data through a particular business, that it now becomes transparent to the business how that data is being used, but also how that data is being protected, because there's a lot of emphasis, of course, within the EU on data protection. And what recourse does a business then have if the data has been either misused or not properly controlled? And so I can see a lot of disputes arising around that area. The regulation itself speaks to the provision or naming of at least 2 mediators. But I think beyond that, there's certainly scope for utilizing a mediation institution. And the benefit of actually using an institution is that you're going to have a much broader panel of mediators to draw from, not simply 2 named individuals. Also looking at background and just capability, timing-wise, to be able to address disputes which might come up quite frequently, and 2 individuals simply wouldn't be able to handle that, whereas an institution would be able to provide the support to be able to do that. Also the scalability, because we don't know at this point in time how many of these types of complaints will be made, and you might have to scale up very quickly to deal with perhaps an onslaught of these types of claims. So utilizing an institution certainly would be wise. The platform provider now has to put in place a complaints handling process. As a part of that process, there's also now the ability to bring mediation into the dispute resolution mechanism. And while it's not clear under the regulation as to how the complaints handling and the mediation fit together, my advice certainly to a provider would be to utilize the complaints handling mechanism together with mediation to be able to bring about a better resolution of the dispute. Because ultimately, either the business or there's provision for business associations and perhaps other bodies within a state to also bring claims against the platform provider. So in order to be able to ensure that there is a proper mechanism in place to resolve these disputes, certainly mediation is an important element of it.
CEDR are uniquely placed to help intermediation service providers become compliant with the regulation in time for the 12 July deadline. CEDR can assist in 3 ways, essentially. The first is CEDR have a breadth of experience in relation to designing and implementing internal complaints procedures. And our skills team can assist in helping a company draft and come up with a cost-effective means of meeting what is Article 11 of the regulation, which is to institute a fair complaints procedure. The second way in which CEDR can help is, as part of that complaints procedure, if the intermediation service provider so wished, they can outsource the administration of that. And CEDR's consumer team often deal with these type of cases and would be able to assist in relation to that. The third way in which CEDR can help is in acting as the named mediation service provider, which would allow the intermediation service provider to comply with Article 12. As part of Article 12 of the regulation, the intermediation service provider is required to name at least 2 mediators who it is willing to refer disputes to between itself and any business that it interacts with. CEDR can provide a breadth of mediators who can deal with a whole host of commercial disputes. They have extensive experience in this area, and because we have a significant panel with experience in this area, we're able to provide a cost-effective and proportionate solution depending upon what is in dispute. CEDR is the largest provider of ADR services in the EU and has been in existence for 30 years. As we celebrate our 30th anniversary, it's very clear that CEDR has been a thought leader in the mediation space and that it has been one of the tenets of mediation within Europe. It often assists large corporates, it assists big international organizations, and it is seen as a thought leader in this space. In addition, CEDR have mediators on the ground in 12 of the members of the EU, and they also have mediators who can speak 15 of the languages, which are official languages of the European Union. So CEDR have the breadth and the depth to really service internet platform providers in this regard. CEDR have a whole range of mediation solutions which they are able to provide for B2P disputes. This can range for everything from a time-limited telephone mediation for low-value disputes, straight up through to a bespoke process-designed mediation involving multiple jurisdictions and multiple parties, which may take place over a series of days or meetings, and everything in between. So that includes video conferencing for mediations, that includes your standard one-day mediation. It also includes half-day mediations. It just depends on where the parties are, the value of the dispute, and the complexity of the issues which are involved. One of the things that is a really unique point for CEDR is we have within our commercial team a team of client relationship associates. These associates deal day-to-day with parties who range from litigants in person to sophisticated in-house counsel to private practice lawyers in order to help guide them through the mediation process and book mediations. These associates will be on call for anyone who is booking a B2P dispute and will be able to assist them through the process. We very much appreciate, in particular with the businesses, that if you're dealing with small to medium-sized businesses, they may not be familiar with the mediation process, and therefore it would be helpful for them to have someone who can walk them through the procedure. In addition to providing a great bench of mediators, administrative support that is second to none, CEDR also have a great website with a host of tools and resources for anyone who is participating in a mediation, whether it's B2P or not. That includes model contract clauses, which are in, I think it's 22 different languages. There are also model mediation agreements, which are used not just by CEDR, but also by most mediators who operate in particular in the UK market. And there's a model mediation procedure. There's also guides which set out guidance for the parties so that they can see what they should expect when they rock up to a mediation and so that they're not taken by surprise on the day.